the next segment of our program, and that is the panel discussion. I would like to call up my panelists, please. Gérard, I'll start with you. Gérard du Plessis. He will be talking to us about the cracks case. He'll be filling in the cracks. Gérard is a senior partner at Adams & Adams and specializes in litigation relating to trademarks, copyright, unlawful competition, domain names, and advertising law. You may grab your seat, Gérard. It's all right. I think you can, sit there at the beginning. Thank you. Next up is Danny Doman. Danny is a partner at Adams & Adams and specializes in patent litigation. He is a partner at Adams & Adams in patent litigation section, specializes in patent, design, plant breeders' rights, and intellectual property agreement, litigation, commercialization, and opinion work. That's a lot, Danny. Next up, Darren Olivier. Darren, where are you? As he makes his way up, a quick intro for him. He's an experienced IP advisor and partner at Adams & Adams. He has over 20 years experience gained in local and international law firms as well as in-house. Following Darren is Tandiwe. Tandiwe is an associate in the litigation department at Adams. She has taken interest in public procurement and administrative law and the role it plays in governing societal norms and structures. The last person on the panel is Yak Mare, also a partner at Adams. He is a litigation and dispute resolution specialist who represents and advises clients in multifaceted litigation, including arbitration and mediation in various fields. So if you've got a fight, he's the guy.
I think I'm turned on.
I'm
sitting very quiet.
Yuck. Guys, welcome. Gérard, I'll hand over to you.
Good morning to all of you. To follow Brent's wording, I get to share some details with you on an interesting trademark case that went all the way to the Supreme Court of Appeal and in which we received judgment just a few months ago. But before I take out my trowel and my bucket of polyfiller, let me just see how many of you remember this.
How you eat your salty cracks may depend on the time of the month. There's the payday salty cracks snack, the mid-month salty cracks snack, the end of the month salty cracks snack, and the very end of the month salty cracks snack. Pyatt salty cracks, delicious with toppings or without.
Right, a true bit of advertising nostalgia. So that gave away, this matter concerned the Salty Cracks brand. So just a bit of background about Salty Cracks. The trademark was first registered in 1951, so more than 70 years ago. It's been with us for a long time. It's currently sold in more than 2,000 retail stores and several hundred convenience stores in South Africa. It's also sold in more than 10 countries in Africa, as well as in the UK, the USA, and Australia. It's a brand owned by National Brands. And at the time, and it's still the position of the case, National Brands held almost 2/3 of the savoury biscuit market in South Africa, of which about 15% is attributable to Salty Cracks specifically. The net sales for Salty Cracks in the 5-year period from 1999 to 2014 totaled just over 670 million. So that's on average about 120 million per year. The relevance of that specific time period will become apparent shortly. And then between 1994 and 2009, National Brands spent more than 11 million on advertising Salty Cracks. So what was the problem? There you can see a new entrant on the market. In August 2014, snack cracks appeared on the shelves in shops. Obviously, National Brands was not happy about the new competitor, really mimicking the existing and well-known product, and took the following steps. First, they had to institute infringement proceedings to prevent the continued use of the snack cracks trademark. But there was another problem. Cape Cookies also filed a trademark application for the Snack Cracks trademark in Class 30, and national brands had to prevent Snack Cracks from getting registration, because apart from losing exclusivity on the register, it would also provide Cape Cookies with a complete defense against any claim of infringement. So we think the Cape Cookies were inspired by the Cookie Monster. But what rights did national brands have to rely on? Quite a number of trademark registrations. Firstly, the Salty Cracks mark, as I mentioned, dating back to 1951. And then also a trademark for Snack Time, and also Vita Snack and other marks incorporating Vita Snack. Now, you immediately realize that Snack Cracks is a bit of a combination of Snack Time and Salty Cracks. So the problem is fairly apparent. So off to court we go after the registrar referred the opposition matter to the High Court. So national brands relied on a number of grounds of opposition, 5 of them. I'm not going to deal with all of them in detail. Just some of them included Section 1012. In other words, we relied on the existing user rights, the common law reputation and goodwill, and said that there's a likelihood of confusion. Section 1014, saying that we've got an earlier registration and there's scope for confusion. And then importantly on Section 1017, which provides protection to well-known trademarks. You can oppose an application on the basis of 1017, but hasn't been done before yet. So, especially in the context of Section 1017, protecting against the dilution of a well-known trademark, it was specifically made out that Cape Cookies was trying to sail as close to the wind as possible in seeking to misappropriate the luster of national brands as well-known trademark. And that was really the nub of the case. Of course, Cape Cookies denied all of this. So some preliminary points that were dealt with by the court and also eventually by the Supreme Court of Appeal. Number one, the state of the trademarks register. Of course, that is important to show that you have some exclusivity in marks in the class, especially ending with cracks. And fortunately, national brands could show that. So apart from the Snack Cracks mark that was filed in 2013, and with one exception, it was only national brands that owned marks ending with cracks in the class. I'm saying one exception. In 2009, a mark was registered for Eticracks in the name of a third party, but fortunately at the time, national brands took action and got the mark cancelled. Then the next item that sort of was given quite a lot of attention, both in the High Court and in the Supreme Court of Appeal, was the explanation offered by the respondent, by Cape Cookies, about the adoption of the mark. So right up front in the founding papers, we challenged them to explain why they adopted the mark and where did it come from. So the deponent offered some explanation. The first was that he regarded the cracks term as a modern and trendy abbreviation for the term crackers. Secondly, he claimed that it is a common abbreviation for crackers in the UK without really presenting any substantiating evidence. And then thirdly, my personal favorite, he claimed that his late mother used the term cracks to refer to crackers, so my mom said it's okay, so I can use it. And then he also proceeded to say that although he's been involved in the biscuit industry for many, many years, he's never heard of salty cracks. So the next item I just want to focus on, also given quite a bit of attention by both courts, was the issue of actual confusion. Now, as you will appreciate, it's very seldom that you have actual evidence available to the court, and that's why the Act and the law makes provision just for a likelihood of confusion that is sufficient. But in this case, there were 2 bits of evidence of actual confusion. Firstly, there was a consumer who was confused and gave an affidavit. And secondly, the consumer journalist Wendy Nola wrote an article about it. And her words were, she said, "As imitations go, Cape Cookies Snack Cracks version of Baker's Salty Cracks is among the most blatant I've ever seen." So we thought this is fantastic evidence to show that there is a scope for confusion because there was actual confusion. So how did the court look at the aspect of confusion? Very, very strangely, this is the judge said the following: the evidence of actual confusion is outweighed by the absence of evidence of widespread confusion. So in other words, the evidence you have is outweighed by the evidence you don't have, which is a bizarre approach. and with specific reference to the evidence of confusion, not really putting too much weight to the consumer who made the claim of confusion, but with reference to Wendy Knowler, the court said, well, the fact that she wrote the article means that she wasn't confused. If she was truly confused, she would never written the article, which is really, it doesn't really make sense. But anyway, the court also referred to the long period that the two products were sold side by side. And you can see on the screen that is an actual shelf in a shop where the products are sold side by side. And there's not sufficient evidence of actual confusion. But bear in mind that the product only appeared on shelf late 2014, and the opposition was already filed early 2016. It's less than 18 months later. It's not as if there was a long period that confusion could have taken place. So the court found, and it's difficult to understand the exact sort of wording used, but whether notional confusion or deception is likely is improbable. That's what the court said. So the two marks are not the same, also similar as to cause confusion. And to confirm that, the court said, National Brands has failed to establish that the prospective, I think that's meant trademark, is inherently deceptive, which was not something that was ever argued, or the use of which would be likely to cause confusion. And then the court said that, the judge said, I'm not persuaded that the common element cracks is sufficient to deceive or cause confusion. Now, bear in mind, cracks is the only distinctive part in both marks. You cannot get right in salt, you cannot get right in snack. So this is the distinctive part, and that was the common element, and the court said, not good enough. At least there was an admission that salty cracks is a well-known trademark. But the court did not find that there is sufficient evidence that unfair advantage is to be had by the respondent in using the snack cracks mark. So the Cookie Monster quite happy, round one. So the order that was made is that the mark should proceed to registration. National Brands was ordered to pay the cost of the opposition. And of course, we couldn't leave that unchallenged. So we applied for leave to appeal. The court only granted leave to appeal on one limited ground, and it was a bit of a side issue actually in the case, and not on any of our main grounds of opposition. So we had to petition the Supreme Court of Appeal for special leave, and fortunately the Supreme Court of Appeal gave us leave to appeal on all grounds of opposition that were raised before the High Court. So there we followed the yellow brick road. You'll see it's a narrow road and a bit windy, but there we were going to seek justice. When the Supreme Court of Appeal gave its ruling about 3 months ago, it gave a summary of the facts and then immediately zoomed in on section 1017 and didn't have to deal with any of the other grounds of opposition, which was interesting and a good thing, because we've never had a case on section 1017 before. And just to recap, that is protection allowed to well-known trademarks where you can oppose a pending trademark application if that mark is identical or similar, and it's not confusingly similar, just similar to the mark that's registered and that's well known, if the use of the mark is likely to take unfair advantage of or be detrimental to the distinctive character or repute of the well-known mark, specifically notwithstanding the absence of confusion or deception. So you do not have to prove any confusion, any likelihood of confusion, you just have to prove these two grounds. The difficulty is that because there was no precedent and previous case law in section 1017, the court had to look elsewhere. So the closest there is the corresponding provisions, really the mirror image of 1017, but in the context of infringement, section 34(1)(c). And I'm sure that you will remember the well-known case of Sab Miller versus Laugh It Off, the Black Label T-shirt case, where breweries were successful in the High Court as well as in the Supreme Court, but it was overturned by the Constitutional Court, and there a lot of attention was given to section 34(1)(c), which really follows exactly the same wording, but just in the context of infringement. I'm just going to look at two requirements of section 34(1)(c), because that is what the court looked at in this case. First, the mark must be identical or similar to the registered trademark, and then the question of likely to take unfair advantage of or be detrimental to. because the way in which the Constitutional Court dealt with it in the Laugh It Off case created a huge problem. So when Judge Moseneki gave the judgment on behalf of the Constitutional Court, he basically added another requirement. He said that the claimant must also establish a likelihood of substantial economic detriment, which is almost impossible to prove. You can imagine that breweries, how can they show that because of the sale of t-shirts, they're going to suffer a financial loss? It's just not a possibility to prove it from an evidentiary point of view. So in a sense, the Constitutional Court drew a line through 34(1)(c) and made it impossible to rely on it. So how did the court approach that in our case? There was another interesting submission on the application of Section 1017 and 34(1)(c) for that matter, and that is, it was argued that it cannot apply where the goods are identical. It's only applicable if you have different goods or services from the goods covered by your registration. And the reason for the submission is that in the United Kingdom Act, and our Act is very much based on that Act, it specifically says your anti-dilution provisions only apply to goods and services not covered by the registration. Our Act does not say that. The language of our Act is quite clear. Unfortunately, the court said Section 1017 is certainly not limited to matters involving different goods or services. It can be any goods or services. So the SCA started by firstly summarizing the correct test in opposition proceedings. It is not a question of how the parties use or intend to use the respective marks, but how they would be entitled to use them if registration is granted. So it's a wider test. And the court just reaffirmed that for purpose of Section 1017, no evidence of actual confusion is required, although there can be confusion, even if the goods are not similar. In this case, the goods are identical. So immediately recognizing the dominant element of both marks is the suffix cracks, and that is what would be the memorable element for consumers. And that whereas Cape Cookies contended that it's a descriptive term and even alleged that national brands conceded it was, which was not the case, the court said that's not so. It's a coined word, it's definitely capable of distinguishing, and then continue to compare the marks. In the affidavit put up by Cape Cookies, they tried to analyze the differences between the two marks in a very scientific way. They listed what they called 13 differences between the marks. Number one, they couldn't count because the first difference, for instance, they said is the one mark is 2 syllables. The second difference is the other mark is 3 syllables. Now that to me is one difference, but they tried to expand their list to 13 of them. But as you will know by now, that when you compare trademarks, it's not an exercise done in a laboratory under a microscope. You're not supposed to compare the marks side by side. That's exactly how you should not compare the marks, and the court just confirmed that. And then looked at the similarities between the marks and found that that there's definitely a similarity sufficient enough to sustain the opposition. And the SCA just said that the prefix snacks is not sufficient to distinguish the respondent's mark from national brand. And then it had to deal with the question of detriment and advantage, the problem coming from the Laugh It Off Constitutional Court judgment. And the court said, just identified what it means, and then said that concrete evidence of such detriment or the advantage to the respondent is not a requirement, it's only a likelihood that must be shown. And then in some circumstances, that likelihood of detriment will be assumed. Fortunately, in this case, we're competing products, and the court said it's not so difficult to draw an inference that there will be an advantage had by the respondent if the mark was going to be used. And then on the argument of the riding on the coattails and the dilution of the Salty Cracks mark, the court said that definitely the use of the similar mark will enable Cape Cookies to ride on the coattails of national brands as regards the well-established Salty Cracks mark without itself having expended the time and invested the money to compete equally with national brands. And again, back to the explanation on the part of Cape Cookies as to why it adopted the mark, the court just said that the explanation is not really acceptable. And there was also a challenge to Cape Cookies to disclose the instructions to its marketing agency with the designing of the packaging, and they refused to do so on the basis of confidentiality, and the court said that's an indication that they probably tried to sail too close to the wind. So the outcome was that the court said in all the circumstances, if registration was to be allowed of the Snack Cracks mark, it would probably or likely take unfair advantage of the distinctive character of the well-known Salty Cracks mark. So the ordinary universe being restored, the opposition was successful, the mark was refused, and the Salty Cracks brand lived to fight another day. Thanks.